Welcome everybody to our 100-year lifestyle training call today. We have a special guest today. You know we like to play offense, defense, and special teams, and we have defense and special teams here today. We have a good friend of mine who I've met through my work with Chiro Congress and the Chiro Future group that is doing great stuff out there for our profession. Attorney Michael Coates, welcome, my friend.
Thank you, buddy.
Really appreciate you being here. I was talking to Michael. We see him at least once a month on our calls where we get together and we talk about things for the profession that are really important. And he was telling us about this No Surprise Act. And I was quite surprised about this No Surprise Act, Michael, because I had never heard of it before. And I guess it's really important because you're speaking all over the country about it. And we do not want our people to be surprised. We want them to always be ahead of the curve. So first of all, welcome. Tell us a little bit about yourself, why chiropractic, and let's get into this No Surprise Act.
Oh, thanks, Doc. You know, the first thing I want to applaud you. I mean, I've known you now for a while, and I really am enrolled in how you advocate to stand up for your rights. You do it in all levels. That's for the patient, for yourself, for your practice. And that's really a big part of what my theme and what my company is all about as well. So I thank you for all that you do and all the benefit that you give to all of the people you speak and are before and what 100-year lifestyle means. And I'm so jazzed that you've expanded this. I've been waiting for you to expand this.
I know you have.
Thank you.
We are constructed, man. We've been under construction. I feel like I've been let out of a cave because you'll learn, like with this new article that we had out, we are promoters. We want the world under care. We've done it for decades. And so let's talk about this No Surprise Act, because if we're going to put ourselves out there, and we're going to attract the planet to what we're doing, we got to have our back also. So tell us, what is this? Why is it important? Why do we need to know about it?
Yeah, first of all, so give just a little background on me. I am an attorney by background, practiced at licensed in California, where for the last 10 years, I championed hundreds of providers, mostly chiropractors, but all medical specialties, in thousands of matters, dealing with hundreds of law firms to recover millions of dollars. So that's been about really helping in personal injury. But this niche is so much broader. So around the country, I really coach, teach, and train about being a better business owner, because you're great healers, but you really got to also get on the business side of what you do, not just PI, but these things really go on both things. And the NSA is a great example. The No Surprises Act is new law. Now, if I had you, of course, you're all hidden here right now, but I've asked you to raise your hands and say, who here has even heard of the No Surprises Act? Almost every time you're going to find 1 or 2 out of 10 have even heard of it. When I was in Florida teaching before 750 people, it was less than 10%. So I know that would be the case around the country. And the problem is, here's the risk. For this year, any patient who could have pulled money, who did pull out money out of their own pocket to pay for your services and had health insurance that might have covered some of it, you potentially could lose that entire bill. So I want to set that a little bit right now. And next year, you're going to have government fines. So what this is, the No Surprises Act started because, you know, when patients came into, say, hospitals, emergency, you had an accident, right? Motor vehicle collision. You came in thinking, I'm in a in-network hospital. I know my coverage is limited. Maybe I've got a high emergency only coverage, $8,000 out of my pocket, but that's all I'm going to have to pay. And you come out of there, and some people with like a $300,000 bill. So unfortunately, the medical field universally has not regulated itself. We did not really do, I know Dr. Plasker is really great with medical bill transparency, but a lot of others aren't. And that's part of the problem, is that providers weren't really displaying. You might give a fee schedule, but that's not telling someone how much they're going to really have to pay. And so because of that, the government, with their long arms, what do? They're going to reach in. And that's what they did here. It's requiring you to give what's called a good faith estimate in advance of care. And the reason is so that your patients aren't surprised by medical bills. They know when they got to come out of pocket and how much, but also they can shop for a better deal. American, right? Really cool. But there's a hidden agenda that I believe that's also here. The government really wants to further lower medical reimbursements. That's occurring with this too. So you've got to be really aware that if you're not complying, you're going to have a real problem coming down the road. So compliance is not only coming up with these good faith estimates, you've got a new consent you've got to put in place. You have notices of the right to good faith estimate. You must have prominently displayed in your practice, generally by the front desk where they're paying. And if you've got a website, it's got to be on there too. So if you don't do these things, the government can fine you up to $10,000 per incident. Now, they didn't do that this year. They say they're starting that next year. The larger thing for you all is that the patients can do what's called a patient provider dispute resolution process, PPDR. They pay 25 bucks, go to an online site, type in, and now they've initiated a dispute. And if your good faith estimate, if you never gave one or were off by at least $400, whatever you did an estimate on, they can get out of that entire bill. And you can bet your bottom dollar that the government's going to make sure they're going to be on the side of the patient right now.
Yeah, well said. And let me just, I want to back up a little bit for our people here. I just want you to know that there's 80% of this we have in place for you without even like Michael was saying, that we're really good at being transparent. I'll tell you what you said, Michael, that is, we find to be true. We had an Indian family that was in an accident right in front of our office. And they came in, we actually went out there to help them before the ambulance came. We built, there was no blood and guts anywhere. They didn't need to go to the hospital. They ended up coming in as patients and we took care of them. We always have our fees, always. So our fees are on our website. They came in and so great relationship, no problems. Well, they started referring people and they started referring their community. And here's what their community said, which is exactly what you were saying. We do not understand the system in this country. There's the fees that they charge. We went to the hospital for something and we thought it was going to be $1,000 or $2,000 and we got a bill for $150,000. And so I can see the need for something like this.
Well, let me use personal injury as an example. I'm willing to bet all of you that have personal injury patients, excuse me, only send your bill to the attorney and after you finish treatment. But let's say you go buy a car. You don't get the car, drive it to your house, park it in the garage, use it for 3 months, and then call up and say, how much did I pay? So giving fee schedules doesn't tell someone how much they're going to have to pay or be obligated to pay for, right? So there was really a need to have something. I just think I'm worried about the misuses. Now, what you're doing is awesome, but I think all of you, there's a great resource to go to. The Center for Medicare and Medicaid Services is taking kind of the lead. 3 government bodies came in to oversee and create this, but one really has the lead, and that's cms.gov. If you go to cms.gov/no surprises, you'll see what they've got listed there for resources, some forms like a good faith estimate, a consent. I highly recommend you look at those because whatever you're doing, you want to make sure you're complying with what they've got to better protect you, which could easily be done with Dr. Plasker's process, since you are very detailed. However, there's a big difference now, starting January next year. So let's say you're treating someone and they've got to get imaging. In fact, you think most likely they may have to go to a pain physician also, or some other specialist, because of what they described to you is their problem. You actually have to include co-providers and co-facilities in your good faith estimate, starting then. So that means you're going to have to include the MRI billing estimate. You're going to have to include perhaps the pain management referral. Right now, there's some nuances and, we don't have enough time to get into the first visit nuance. I'll just tell you a little bit. You've got to give these estimates in advance. If they made an appointment with you at least 3 business days in advance, you've got to get them this good faith estimate in writing. If it's less than 3 days, you don't have to, but generally for chiropractic, it's recurring services. So by that second visit, you better have that full-on good faith estimate. And you being a good provider, with that condition, what likely it's going to entail, how many visits. This includes wellness care. Anything in which even cash pay patients, if they have insurance, even if you aren't taking that insurance, but if insurance could have covered some of this, you got to be able to let them know and comply with the act. They got to know.
So we have forms in the vault that are, we don't call them, I forget the word you use for this form where you list the services.
Well, good faith estimate, GFE, that's the key terminology now.
So does it have to say the words good faith estimate on it?
Well, I would say this, there are specific, I definitely would put good faith estimate. I'd use their terminology, mirror back to be more in compliance, but look at that form because it's requiring you also to be better diagnosticians, which I love. I mean, that's great for the industry, right? Because now you've got other people looking at what you did. So if a patient does a dispute, here's what's also going to happen. Some third party is going to review what you did. They're not just looking for what the patient said. They're going to be looking for, did you support medical necessity on what you provided? That means they're going to make sure that you matched diagnostic codes with your SOAP notes, with the actual treatment provided. And they're going to be looking at all that. And if they find that isn't the case, you're going to find other things probably kicked out. I'll give you an example. Hot packs may be great, but if you're using them over, a 3-month period, something they might buy at CVS, probably you're going to have an issue with that at some point. So I'd be very careful that be a better diagnostician, make sure you've got that tie in between all of it because you've got more scrutiny coming to you. And Dr. Plasker, this is really important. It's not just the government. Remember, it says people are going to start to inform patients more about their own rights. It'll get out there more. There'll be a bigger push coming next year. There's another wild card in here, and that ties more to personal injury, but it's the PI attorneys. Anything they can find to screw you on your bill, they are going to use. And so they're going to say, where's your good faith estimate? You didn't do it. You're not owed that bill, or you better take these pennies on the dollar. I've had it already happen. I've seen it with providers in different states for work that was done this year. So it doesn't apply, but they're trying to prey on you on your lack of knowledge and lack of confidence. You got to study up. You got to know what this is so you don't get taken advantage of.
Yeah, I really I appreciate the conversation. And I also appreciate the fact that, for a lot of you, I know you're implementing slowly or steadily some of the things that we're teaching you. There is a form that we have where we put the crisis care and that critical transition lifestyle care literally side by side. And it says on there right now, it says estimated number of visits. And it says, and we recommend that you put in, if you have special services that you are doing, that you add those both on the crisis care and that critical transition lifestyle care side, so that you have yourself covered. And it is with, like you're saying, it's with cash patients, right, Michael? You have to do it with cash patients, insurance patients, PI patients. Everybody that you see should get that form or some version of that form.
Yeah, my recommendation is it's hard for staff to try to decide which to apply something and which not to. I think it should be on every patient as just a standard practice because it really applies to uninsured and self-pay patients. So the big issue on that is self-pay. Like, what is self-pay? To me, and I am interpreting it all, it's anytime a patient's got to pull out of their pocket. So at first this year, it's not been going with those with insurance coverage. It's basically, I have insurance, but I choose not to use it for some or all of the services. That for sure is self-pay. But their intent isn't just that. Let's say I've got a large deductible, $1,000, $7,000. I assure you the NSA is going to bleed into that because what they don't want someone is sucking up that deductible as a surprise. So I just think it's going to be better to make it as a standard practice, which is good. I think it's good as an industry, transparency. Would you not recognize, Dr. Plasker, that we in the medical industry, there's a breach in trust overall with our clients, the patients, and that comes around billing. It's the highest debt in the country is what? Medical debt.
Yeah, it's the number one reason people go bankrupt. It's the number one people that it drives companies out of business, healthcare costs, and trying to understand how to deal with that. And I think that for all of you, because Michael's learning about our group, we've been doing this, we've been training doctors for a long time. We are pretty much solid in this area, but there are things that Michael is talking about. What are the things that, let's say, Mike, let's say a doctor's got 80% of this in place. What are the 20% that are usually missing that they need to immediately address? And then I want to move also into, once we get through this, I want to go into personal injury and give us some important tips related to personal injury, because we have a lot, like in our practice, we don't go after personal injury, but we have people that get in car accidents. So we do get a little bit of personal injury here and there, and we like it because those people need us. What are some things that our people, who some of them do a lot more personal injury maybe than we do, that they need to know that is related to this, as well as some of the things they need to be aware of that they might not know?
Hey, PI is the best paying segment of any practice because you're getting your retail rates. But on the NSA first, again, I think you got to look at the form that cms.gov has, /no surprises, but realize there's also disclaimers you must have on the estimate. And you have to have each of those on there. So there's these little things that got to get checked off once you've got a compliant form. So I think that Dr. Plasker, even you, if you take a look at what you usually do in that, I think you will need to modify, I'm certain of it, what you have. It won't take a lot, but like you're having codes, the description, what does the code mean? You literally putting the frequency up, it's going to be 6 months, 3 months, whatever it is. These are the days. Here's when it changes. Here are the modalities, right? You're listing all that and the total, and you got to put the total, right? So that's really important. So you've got the consents, you've got the good faith estimates, you've got the timing of these, and the time depends upon how far in advance they schedule the appointment, when you've got to give this, and it needs to be orally and in writing. And these are medical records. You've got to keep them for at least 6 years. So when you do this, HIPAA privacy applies. So realize that too. And so protect those documents, because you'll have to come up later and prove what you did. So with that, and by the way, again, we can only cover so much. Like I teach right now, the head of legal for Florida has me going to all their regionals and their national, teaching them, and I'm doing it in other states as well. So if you want more details later on, I can just contact me, whatever. We need a deep dive. Your staff needs a deep dive. I'm going to be doing one December 10th on a deep dive, like a half day, really covering everything on the NSA. But let's get to personal injury. So PI is really important because it is the best paying segment of really any practice because it is the retail thing. Here's what attorneys don't want you to know. You have the control. The 4-minute mile in PI should be, you get paid 100% of your retail rate, 80% of the time. What if you could do that for your practice? What would that mean? That's why PI is so important. And when I say that you have the control, in almost every state in the country, whether you're a lien state or letter of protection state, the patient owes the bill regardless of the outcome of the case. The attorney's on contingency fee, not you. You guys are the heroes of PI, let me tell you, because first of all, you get them out of pain, and you do it without surgery, needles, or pills. We need more of that. Number two is it's your treatment, your billing, and your SOAP notes, especially when you do storytelling documentation in those subjective findings, that supports the pain and suffering of the patient in PI. You know that your patients could literally get a recovery from the insurer without the attorney, but they can't without you. They have to have the medical expenses that supports the pain and suffering and what happened to them. Okay, that's the second. The third is, after all of that, you agree to wait, sometimes years, to be paid. But that waiting is worthwhile. Truly, because the difference between healthcare reimbursements that are getting crammed down even more and what you can get in PI. So I want you to realize that you have the leverage over the attorneys. You've just learned, I call it negotiations Aikido. It's like using the energy of your opponent against them offensively and defensively. So like Dr. Plasker talks about offensively. Well, in PI, you've got to sometimes do a little offense. And that mostly surrounds, like we're talking about, transparency.
Yeah, we had a situation where we had
making the attorneys be transparent on that settlement recovery. If you know what the settlement was, the attorney's fees, the costs, what they really use the cost for, the medical liens, gross and the net to the client, you can see what's fair or not fair. They want to hide that, but you can compel even by their own ethics rules for your state to compel them to provide that when they say it's confidential, because that's a bunch of BS. Sorry, go ahead.
I love what you just said. So most chiropractors don't know what you just said. We had Corey had a PI case, and the attorney called him up and said, hey, so listen, here's, we're going to give you 50%. He didn't even ask. He didn't ask, would you take 50%? He knew that Corey was young. He asked, will you take 50% of this bill? That's what we can afford to pay you. And Corey said to me, he said, Dad, this is crazy. They want to give me 50% off. And I said, well, what was the settlement? What was the settlement? What did they take for the settlement? And he didn't even think to ask that. And a lot of doctors don't even think that they can ask that question.
What you ask for that one document, they have to give their client what's called an intended disbursement listing. So it's either by letter or a separate document that actually puts, here's how much the case settled for, here's the attorney's cost, the attorney's fees, all the lien holders, net to client. And that's what the patient's looking for. How much am I getting? What they're not putting in a lot of those documents, though, is it doesn't say, when they show these reductions of liens, including on your bill, hey, we haven't even talked to the doctor yet. So the patient is thinking this is what they get when they really owe whatever it is of your bill, regardless of the case outcome. And that's where you get them starting to push back at you, because now they put things in a corner. Now, there are some common fund states, but even in the common fund states, which protect the patient to make sure they get a certain amount of the settlement, they usually say the patient still owes the remainder. That's why attorneys still want to do what they call a full and final satisfaction. So like when you say, Dr. Plasker, I've seen where a lot of times attorneys will send a check to you. Here's your payment, and it says full and final on it. They're hoping you just deposit it. Once you deposit it without knowing anything else, you're done. It's called an accord and satisfaction. Done, finished. And when they pay you 50%, do you know that most of them think they overpaid you when they paid you 50%?
Yeah. So if you didn't agree to that payment and it's less than what your fees are, and you don't deposit it, you can call them out on it and actually negotiate that fee, or say,
I do more. I would write big void, big letters on the front and back of that check, fax it back to them, email it to them, and mail them back that voided check and say, hey, not that I'm saying I'm not ever going to take this, but I'm not, because if you put a voided check, they've got trust account fiduciary responsibilities. If you're just holding a check, they're going to hope you're just going to, at some point they delay, you'll just mistakenly deposit it. When you void it, they got to do something, right? By their own duties. That's why I say it's wonderful. The state bar ethics rules in your state, generally rule 1.15 of rules of professional conduct, applies on most states. It's an ABA rule that most adopted. And that puts the protection of medical providers, you guys, third parties with an interest in a lawsuit. Specifically, it's meant to be you guys, to have the right to a full written accounting. Not partial, full. That's why when they say confidentiality, how can you make a business decision of taking less when you're entitled to it all? Just like the law firm, they may have a priority on payment, but they have no greater right to get paid in full than you do. And you finished your work long ago before they even really started theirs.
Yeah, that's really good advice. And so, how did you get into, were you always into personal injury, and why all of a sudden are you taking such an interest in chiropractors? Because obviously you're volunteering your time, and I know there's a lot in it for you from a business perspective, but you have a passion for chiropractic and for chiropractors. What drives that for you?
Well, I do, because I see so many struggling, and they shouldn't. The chiropractic practice in particular, many of them are just surviving month to month to get the bills paid. They should be thriving, not just surviving. I actually got started in this a little over 10 years ago when a chiropractic friend asked me to help him with 5 attorneys that had medical lien problems. And I didn't know what this was. I just said, I got him 100% paid on all 5 bills, and his jaw kind of dropped. Do you know what you just did? I said, no, what? Well, when he explained, I couldn't believe what he was telling me, because I had not been exposed to the abuses, the wrongdoings, the lies, the tricks, the traps that many of the PI attorneys, now there's a lot of really great PI attorneys. I have friends that are great PI attorneys. There are too many, though, that are not. They prey upon the medical provider because they want their fees, right? They need their client, your patient, to be happy, to not only refer, but not to nail them on social media. So they have one group to put the burden of bad settlements and bad results on by them, you guys. And you don't have to take that. When I saw that, I said, this isn't right. This isn't fair. And I had really been looking for a better cause. I used to, in the back, I represented, like I say, I was doing medical malpractice defense and personal injury defense in my early years. Then I was working with a partner in a major law firm, national law firm, representing banks and financial institutions. All those things didn't give a crap about the little guy. I get to help people that really deserve it. Medical providers who, as I said, you guys are heroes. So that's why I love this. And I need to see you guys all thriving. So I'm going to do everything I can to make sure you do. And a lot of that is you don't know what you don't know. You do that, Dr. Plasker, and you educate, inform, and coach them. And I just do it in this kind of space of personal injury and the NSA and certain nuances, because I want you all to be better business people, not just great healers, because I need you to thrive. The world needs you to thrive.
Yeah, it's really, it's a timely discussion, and I appreciate that you offered up your time to us, because this article that just came out on chiropractors being essential, that I know you're sharing and Chiro Congress is going to share, like a lot of associations are sharing. It's really exciting how it's getting out there, that our journey from persecuted to essential, and literally in the way we are getting paid, we are going from persecuted to essential. So it's important that we take this out for a drive, that we stand up, not out of just ego, but like you say, I mean, we're heroes in many ways, not just in personal injury, but we are heroes to our communities, because the status quo is crumbling. We've talked about it at FCA and at the national. I had a whole section on how the trust in the allopathic world is crumbling. There's a parallel universe that's trying to be created in that medical world right now, and it's struggling to get footing, because there's so much distrust in the medical world right now, and chiropractors are literally rising up. It's such a great opportunity across the board. And I know you're doing special programs on this, Michael. Tell us how people can get more information if they need a deep dive, if they want to take a deep dive. You have special, I think, webinars and trainings that you're doing. How do people connect to that?
Well, thank you. Go to just our website, pimadeeasy.com. I know personal injury made easy seems like a play on words, but that's the whole point. When you learn how to do things, the three foundations we build on: proven processes, being profitably paid, and accelerated growth, and hitting all those areas. Because the wonderful thing for what you're doing is that symbiotic relationship between injury care and wellness care. They fit side and side. And PI is just a subcomponent of injury care. So I believe in doing both and having a nice balanced practice. So go to pimadeeasy.com. We do have December 10th. We're going to do a half-day deep dive. We'll be coming out with that soon with information. But there is one thing I want to leave, a value proposition that I want to leave you with still about PI, that is part of what I really shout from the highest mountaintops. And it's regarding MedPay and PIP. You're either in a MedPay or PIP state, or they have both. This is, even in PI, you can get quick pay by PIP or MedPay, because the intent is prompt payment for prompt services for those injured in an accident is part of the auto policy. The problem is the attorneys are holding onto your money, even taking attorneys' fees out. It's a great example of when you stand up for your practice and your patient and your bill getting paid, you're standing up for your patient. Because when you don't get that money and later they've got to maybe pay the MedPay insurer on a subrogation right, some of it back, or they take attorney's fees out, the patient's got to pay what they took. So they're getting screwed by their own attorney, and they're not realizing this. So I would encourage you to stand up in those areas. And one last thing in that area, for yourselves, for your staff, for your family, call your own insurance agent. Do you know that to go from the minimal MedPay or PIP coverage, especially MedPay, to the highest, I went from 1,000 to 100,000 coverage for medical expense for me and anybody in my car in California for $50 a year. That was $99,000 more in protection for $50. Let me tell you, it's better than the auto club. Okay? So I'm telling you, get this to your staff, have them call their agents. If I'm going to advocate one thing to help you all today and your patients, it may not help them on the current accident they have, it will on the next. And it's going to help people pay for your care when that happens.
Yeah, great advice. And I'll give you a little 100-year lifestyle piece of advice for your attorneys and the people that you work with. We've had 100-year lifestyle offices, doctors, they make, with this educational message and reality, make amazing expert witnesses. And we had one of our clients down in Florida, because of his presentation on the stand and the longevity issue related to the accident, he got the client for the attorney, I forget the amount, it's like a substantial increase in the amount of the settlement, because the damages were going to affect this person's life, instead of maybe for another 5 or 10 or 20 years, possibly for another 30 or 40 years, because of the longevity reality. That's a part of what we're learning with 100-year lifestyle. So it's a great synergy here. These people need more lifestyle care, more wellness care down the road, so that they don't suffer. And so it's a great synergy, and we appreciate the connection, really.
Thank you, Dr. Plasker, again, for all you do. And if any of you watching are not a member of the 100-Year Lifestyle, I encourage you to join that. I mean, you will come away with an incredible return on your investment.
Yeah, thank you. And again, pimadeeasy.com, and reach out to Michael. Great guy. You also have something, don't you have something where if you get an offer from an attorney, the initial offer and the doctor doesn't like the offer, don't you have a team that can reach out on the behalf of the doctor to increase the settlement, or do you not do that?
Well, actually, I mean, for California providers, we do, but honestly, for other states, well, we do the fishing in California providers where needed. But around the country, we teach you how to fish because, to be honest, it's a better way. You can actually even give, say, a 10% reduction, get paid 90% of your bill, make the attorney happier because you didn't pay somebody else, like my company, to do it. And yet you can maintain relationships better. You can learn what I've done yourself. So that's why we have a membership program also with monthly coaching and all these tips, tools, and resources, medical liens, letters of protection, assignment of benefits, already preset emails your staff can use. Like you said, what do you ask the attorney? Here, when they say it's confidential, what do you send back to them? Here, making it really easy for your staff. And your staff is the key. As you elevate staff, that's how you get the time for yourself, the profits for your practice, and the freedom to do what you want, when you want, with who you want. Elevate that staff, putting in the right processes and efficiencies for yourself and protecting them.
Excellent. Well, listen, if you're doing any PI at all and you have questions about it or you're not sure, Michael will take great care of you. And
well, let me give you my email address too. So it's mcoates, MCOATES @pimadeeasy.com. Or you can do it through the website too. So happy to have you guys reach out, go through the website or me directly, whatever it is. Anything I can do to help Dr. Plasker's people, I am all in, because I'm all in what you guys are about.
Thank you, man. Appreciate you so much. And I've met some of his team out in different places. Great team. And we appreciate you having our back. Thank you for taking a stand for chiropractors.
Thanks, Doc.
All right, guys. Excellent. Does anybody have any questions for Michael before he disappears? You can reach out.
Yeah. Can I ask one quick one?
Sure.
Michael, you alluded to the fact that what do we have to present them if we don't bill insurance and they're paying cash? I know we just have to give them a like what we have through the family practice, an estimate of what it's going to cost them. But what do we have to do anything more?
Well, yes. I mean, the good faith estimate is a more detailed, when you think of it as a care plan, what the NSA is really doing, it's mandating term care plans. That's a great thing. Part of the problem of chiropractic is most are the per visit model. I see you. Let's see if you come in again. You come in again. So that's why I love what Dr. Plasker does. It's you are setting upon a care plan. That's how you increase business valuations for chiropractic, because it's a care plan versus a per visit model. That's why when you do what he says in this program, you're worth more. So for here, though, you need the more detailed estimate because it literally needs to follow like the exact codes you're using, right? And the description of what that code is for. What modalities and when are you giving them over what period of time, the frequency, and then giving the total. So it is more involved than what the general estimate is, and then you got to make sure you got the disclaimers on it. So whatever you're using, you may be close, but I'm sure there's a few little things you're going to have to tweak. So just form. It's not going to be difficult to compare to get yourself back on track. By the way, there is so what Dr. Plasker has, there are some software companies that do care plans, like one that I've worked with because I had them tweak it for PI, and they do make sure that it's NSA compliant for what they have. So that's happening out there. You'll see more. Chiro Health has got a lot too on what they do if you're a Chiro Health member. So you'll find that there's a lot of vendors that will help you in this area too.